morning, everyone. My name's James, and I'm joined with Natalie Pratt. We are both members of Radcliffe Chambers, and we are here to talk to you today about property. Natalie will be presenting on the topic of restrictive covenants and remedies for breaches, and I'm going to be giving you a brief overview of how fraudulent misrepresentation can arise in a residential conveyancing context. What we plan to do today is Natalie's going to speak first, followed by myself. If we have time at the end, we may do a Q&A. You should see that there's a Q&A box in Zoom. If you have any questions, that's where you should put them. We won't have any other way of communicating with you. So if you have a question, drop it in that box and we'll try and deal with it at the end if possible. So without further ado, I'm going to turn off my audio and camera and hand over to the very capable Natalie Pratt. Over to you.
Okay, so James has sent age into bat before beauty this morning, and I'm going first, and I'm talking to you about breaches of restrictive covenants. So I appreciate that's a fairly generic title. So more specifically, what I'm going to be looking at, when my screen complies, there we go, overview of my talk. So firstly, we're going to look at what a restrictive covenant is and why they're important. Secondly, we'll be looking at remedies for breaches of restrictive covenant. Thirdly, the ways in which you might think about dealing with a restrictive covenant. And fourthly, we'll have a look at section 84 of the LPA. So a little bit of a whistle-stop tour through sort of covenant breaches, consequences for breach, and sort of how you might think about advising a client to escape liability. So turning first then to what is a restrictive covenant. Now, I appreciate that most people listening, if not everybody, knows exactly what a restrictive covenant is. I think it's worth saying that my talk does focus on restrictive covenants. It doesn't focus at all on positive covenants. And of course, as we know, different considerations will apply when it comes to positive covenants, especially to that question as to whether and upon whom the covenant would be binding. Because of course, if you have successors in title and the covenant is positive, there's a really good chance it hasn't travelled with the land, and therefore there'll be no question of breach or remedy or needing to deal with the covenant in any way, or whether that be by section 84 or otherwise. So a restrictive covenant broadly then is an agreement by deed that one party will limit the use of its land in some way for the benefit of the land of another party. And subject to various requirements being met, the covenant will travel with the land and it will bind successors in title. There are different categories, should we say, of prohibitions that you might encounter. We're looking at restrictive covenants, and they can be broadly split down into two categories. So you might encounter absolute prohibitions, or you might encounter qualified prohibitions. So examples of absolute prohibitions would be a restriction that means you can use the land only for residential use, a restriction on the number of units that can be on the land, the prohibiting of certain activities or businesses being conducted on the land, or just one of those general covenants that prohibits nuisance more generally. Qualified prohibitions then are where you have a restriction or something is restricted pending the fulfillment of some sort of prerequisite. And usually that prerequisite will be the obtaining of permission from the landowner of the benefited land. So for example, a really common one that you've probably already come across is a prohibition not to build any further residential units on the land without first obtaining the permission of the benefiting landowner. Now, really importantly as well, even if the covenant does not expressly say it, there will be an implied obligation that the permission should not be unreasonably withheld. So it may not be expressly there in the covenant, but certainly that will be an implied obligation when you've got a qualified prohibition. So why then are restrictive covenants important? Restrictive covenants can significantly limit what a landowner can do with their land, even though they might not be the person who entered into the covenant. So successors in title need to be particularly on guard and investigate their land titles to fully understand what they're going to be bound by when they acquire land. And that's why reports on title are particularly important in the conveyancing procedure. And as we've just heard James say, he's going to talk a little bit about the conveyancing procedure shortly. Now, as property litigators, we will probably frequently encounter cases where clients have acquired land with a view to building or making significant alterations on that land, only to then later discover that they are prohibited from doing so by a covenant. So to some extent, restrictive covenants can sterilise the land when taken to their absolute extreme. It's also really important to note that restrictive covenants sit outside of the planning regime, and landowners often don't appreciate this. Obtaining planning permission, or if the development that you want to do is within the scope of permitted development rights, or if you have a certificate of lawful development, that does not free a landowner from the burden of a restrictive covenant. It does not permit the breach of a restrictive covenant. The covenant must be addressed separately to the planning regime. So if there's a covenant not to build, the obtaining a planning permission does not permit that building in covenant terms. You have to deal with that covenant separately from the planning regime. And this was confirmed in the Supreme Court in Coventry and Lawrence, and that's where Lord Neuberger says that planning permission only removes the public law bar to development. And Lord Sumption followed that up by saying that planning powers do not override private rights in respect of land use, including restrictive covenants. But importantly, planning permission and permitted development rights can make a difference on a Section 84 application when arguing reasonable user, and we'll look at that shortly. It's also just really important to be aware of covenants and if your land is burdened by a covenant, because if a landowner does fall into error and breach, there can be and there are significant consequences for that. Which takes me to remedies for breach. Really, there are two primary remedies when it comes to breach of covenant: damages and injunctive relief. Now, common law damages are available between the original contracting parties, so the original covenantor and covenantee, and the measure of damages there is to put them into the same position that they would be had the contract been fulfilled, so had the covenant been observed. As soon as you have a successor entitled, though, to the burdened land, enforcement, and therefore a remedy for breach, is available in equity only. And that's because the burden will only travel with the land in equity. It won't travel at law. So if you're looking for damages there, you're seeking damages under Section 50 of the Senior Courts Act. And their damages either in lieu of or in addition to an injunction. And the measure of those damages is this so-called negotiating damages. And they are generally quantified by the sum that the claimant would have accepted in exchange for the release of the covenant and giving up the right to seek injunctive relief. When assessing damages on the negotiating basis, the court has to assume that a claimant could, in fact, have been induced to give up the right, and it's irrelevant if one party would, in fact, have refused to negotiate. And most of the time, the sum that's arrived at by the court is arrived at by assessing the reduction in value of the claimant's land, if any, and a percentage of the profits obtained by the defendant by reason of the breach of covenant, but without permitting double recovery when doing so. The two really key cases on this point I've put there on the slide, so Ruton Park and Morris Garner. Negotiating damages, as you probably know, used to be called Ruton Park damages. They're now called negotiating damages. However, I think it's probably fair to say that most of the time what a claimant really wants is injunctive relief. And so they'll probably be looking to restrain a breach, whether it's an ongoing breach, or they might be looking to restrain it on a precautionary basis, so what we used to call quia time relief. Or they might be seeking a mandatory order to reverse the effect of a breach. So if there's been a building in breach of covenant, you might be seeking a mandatory order to have the building taken down. If you are seeking injunctive relief, the thing to remember that's absolutely key is acting promptly. You must act promptly if you want to seek injunctive relief. There's a really strong body of case law that says if you sit on your hands and allow a breach to happen, that might affect whether injunctive relief is granted when you actually then do seek it. If you could have acted sooner and you've allowed a breach to progress, it could be inequitable to grant the relief. So if you're ever thinking about an injunction, act as soon as possible, but if you're looking at precautionary relief, you can't act prematurely. When it's precautionary relief, there is a fine balance. Next slide there. Yeah, so how to deal with restrictive covenants. So let's assume you are acting for a landowner whose land is burdened by a covenant, and they want to do something that that covenant prohibits. So the classic example is someone's bought some land with a view to developing it, and they then discover that there is a covenant that prohibits building or the erection of any further units on the land. What options can you give them when you are advising? I think really here you've got three key options. The first is that you could negotiate an express release or variation of the covenant, and to do that or to give effect to that, you would need to execute a deed. You need all of the benefiting landowners on board. So it's not a case that a covenant may only benefit one parcel of land. Sometimes it will benefit multiple parcels of land. You would need all of the benefiting landowners on board. And that can be particularly tricky if you have, for example, a scheme of development where there's a particularly large number of benefiting landowners, and you've got parties or lots of parties and lots of land with mutually enforceable covenants. It also requires you to know all of the land that's benefited, and that's not always clear because, of course, the benefit of a restrictive covenant does not have to be recorded on the title register. Option number two is indemnity insurance, and this can be useful if you can't identify who has the benefit of the covenant that burdens your land, especially if you are acquiring land where there appears to have been a past breach, but no enforcement action has yet been taken. And actually, sometimes in those circumstances, indemnity insurance can be a condition of obtaining mortgage finance. These sorts of insurance policies would usually pay out to defend any legal proceedings if enforcement action is taken. It should also pay out any damages that might be awarded to the benefiting landowner through the course of those proceedings, and hopefully it should also pay some compensation to the insured party. And then option number three is you could use Section 84 of the Law Property Act, and you've got two options here. Under Section 84, you could either make an application to modify or discharge the covenant, or option number two, you could apply for a declaration. So if you think you're actually in a situation where the land is not bound by the restriction, so it hasn't actually travelled with the land, or maybe the restriction doesn't in fact prevent the proposed activity, you can either seek a declaration as to whether the covenant is binding, or you could seek a declaration as to the true construction of the covenant. And that's provided for in Section 84, subsection 2. I'm looking today, though, at those applications to modify or discharge. So a few key practical points if you're thinking about making a Section 84 application to modify or discharge. Firstly, that application is made to the Upper Tribunal Lands Chamber. It's not to the FTT and it's not to the court. So everything goes to the Upper Tribunal under the Section 84 jurisdiction. And really crucial is the timing of the application. Now, as a general rule, it's always best to make your application prior to any breach. Because, as I will shortly discuss, once it's established that the court has jurisdiction to modify or discharge under one of the Section 84 grounds, the tribunal then exercises a discretion whether to actually, in fact, modify or discharge. And depending on the circumstances, if a landowner is seeking to modify after a breach, that can really count against them in the exercise of discretion. So that's especially so if you've got a cynical breach, or if you've got a landowner who is sort of trying it on a little bit with the breach, all of that will count against them. Obviously, it will be a different situation if you have a completely innocent breach. That will weigh differently in the exercise of discretion, but as a general rule, you always want to try and make your Section 84 application prior to any breach actually occurring. If a landowner is already facing enforcement proceedings, so there's already an injunction claim on foot, you could look to Section 84, subsection 9. So Section 84, subsection 9 allows a landowner to make an application for leave to apply to the upper tribunal and to stay those enforcement proceedings whilst the upper tribunal proceedings for modification or discharge run their course. However, again here, be careful with timing. So I've been involved in a case where the application to the upper tribunal and the Section 84 application for a stay was sought quite literally on the eve of the PTR. And the PTR took place 1 month before the 2-day trial. And by this point, the litigation had already been ongoing for 2 years. So the Section 84 application was made really, really late in the day. And the judge refused the stay under Section 84, subsection 9. He said it was all far too late and was going to prejudice my clients. So he suggested the way forward would be that any injunction that was granted at the end of the enforcement proceedings could have been stayed pending the outcome of the Section 84 application. But actually, as it happened, even that didn't happen. The injunction was immediately enforceable. So just be really careful with timing and don't assume because Section 84 subsection 9 makes provision for a stay that you will automatically get it. The other thing not to get caught out by in a Section 84 application is that it's not a cost neutral jurisdiction, so it's not like the FTT. So Rule 10, and I think specifically 10.6c, as I put on the slide, the Upper Tribunal Lands Chamber rules provide that costs can be awarded in a Section 84 application. And then the Upper Tribunal Lands Chamber Practice Direction sets out the various rules and procedures governing costs recovery. I've put on the slide some of the particular paragraphs that you need to be aware of, but paragraphs 16.7 to 16.11 are particularly important. So if an applicant is successfully challenging the objector's entitlement to the benefit of the covenant, the objector will normally be ordered to pay the applicant's costs. And then the reverse is true. So if the applicant unsuccessfully challenges the objector's entitlement to the benefit of the covenant, the applicant will normally be ordered to pay the objector's costs. And if you have an objector who is successful in their objection to the Section 84 application as a whole, they will normally be awarded their costs. So far so good, all seems pretty standard, but the one rule not to get caught out by is paragraph 16.10. So 16.10 provides that an unsuccessful objector will not normally be ordered to pay a successful applicant's costs unless they've acted unreasonably. So if your client is applying to modify or discharge, do not assume that being successful in that application will lead to an award of costs in their favour, because the chances are it won't, and in fact it probably won't. And the rationale for that position is that the application is trying to remove or diminish the property rights of the objector, and the tribunal will not normally regard it as being unreasonable to have made the objection and to have pursued that to a hearing. And lastly on the slide, probably not so much a practical point, maybe more a substantive point, but when you're making a Section 84 application, just be aware that the tribunal will deal with it in essentially a 2-stage process. So firstly, you have to establish one of the jurisdictional grounds under Section 84, subsection 1. And then secondly, you have to address the tribunal on the proper exercise of its discretion in all the circumstances. Which takes me then to what those jurisdictional grounds are. So there are 4 jurisdictional grounds under Section 84, subsection 1. And it's common for more than one to be argued. There's often significant overlap between at least 3 of the grounds. The common overlap and combination is something between ground AA and ground C. So ground A is the obsolescence ground. So by reason of changes in the character of the property or the neighbourhood or other circumstances of the case which the upper tribunal may deem material, the restriction ought to be deemed obsolete. Now, crucially, the test for obsolescence is not whether the purpose of the covenant can no longer be served, The test instead is whether the covenant is no longer of any value to the covenantee. I've done that completely wrong. So the test for obsolescence is whether the purpose of the covenant can no longer be served. That's the test. That's confirmed in Restrictive in 1956. It's been restated lots and lots of times, but that is the test. It is not the stricter test. It's not the stricter test of whether the covenant is no longer of any value to the covenantee. Ground AA then is the reasonable user ground. So in cases falling within subsection 1A, which we'll look at shortly, the continued existence of the restriction would impede some reasonable user of the land for public or private purposes. The key case here is really Bass Limited's application, so that's a 1973 case. That case sets out a series of 7 questions that give you the route through the statutory provision, both ground AA and also 1A that supports it. Ground C then is the non-injury ground. So the proposed discharge or modification will not injure the persons entitled to the benefit of the restriction. And crucially, as well as not getting any costs, a successful applicant may also have to pay compensation to a benefiting landowner for the loss of their property rights. That compensation can be paid under one of 2 grounds, but not both. So option 1 is a sum to make up for any loss or disadvantage suffered by the modification or discharge. And option 2 is a sum to make up for any effect that the restriction had at the time when it was imposed in reducing the consideration then received for the land affected by it. So effectively, you're there looking at the difference in value between the burdened land with the covenant and the burdened land without the covenant. So it's the increase in value of the burdened land as a result of the modification or discharge. So as we say, ground AA is tied to subsection 1A. And as I say, those 7 questions from Bass's application give you the route through ground AA as supported by 1A. To clear ground AA, you have to show that in impeding that reasonable user, the restriction does not secure to the persons entitled to the benefit of the restriction any practical benefit of substantial value or advantage, or, so it's a disjunctive test, or is contrary to the public interest. And then irrespective of which of those you're relying on, you also have to show that money will be adequate compensation for the loss or disadvantage suffered, if any. And crucially there, don't forget section 84(1)(b). The tribunal has to take into account the development plan, any declared or ascertainable pattern for the grant or refusal of planning permissions, the period and context in which the restriction was created or imposed, and also any other material circumstances. So pretty broad range of considerations that the tribunal has to take into consideration or may take into consideration. That brings me back then to the planning regime. So as I mentioned previously, planning permission and permitted development rights do not inform whether a breach of covenant has occurred, but it can inform a Section 84 application, and most notably, it can inform whether a proposed user is reasonable for the purposes of ground AA. And I've put 2 cases on the slide that deal with this point, and the cases draw a distinction between those situations where you have planning permission and those where the development is covered by permitted development rights. And that perhaps seems a little bit surprising, given that PD is really just a deemed grant of planning permission. So turning first to the James Hall case on the slide, this was a situation where you had a change of use. So it was A4 use to A1 retail. So it was basically a pub being changed into a shop. That change of use was covered by PD under the 2015 GDPO, but it was prohibited by a restrictive covenant. Now, the upper tribunal considered the difference between planning permission and PD and said that the reasonableness of the use would have been considered if and when an application for planning permission was put in. But that consideration doesn't happen when you're relying on permitted development rights. And so here, the reasonableness of the use or the change of use had not been considered. However, the tribunal went on to say that's not fatal as to whether the user is reasonable, and lent in favour of modification, but crucially not discharge, only modification. Jackson and Roselease does a very similar thing. So Jackson and Roselease was Class Q PD, so it was conversion of agricultural buildings into dwellings, but using the same footprint of the building, the same height, things like that. So that's Class Q PD under the 2015 GDPO, but again, there's a covenant prohibiting, in this case, further building on the land and occupation of the agricultural buildings. So as I say, it's PD, and also here you had a grant of prior approval subject to conditions, and actually the conditions were to seek the modification or discharge of the relevant covenant, or to obtain the consent of the landowner who benefited from the covenant. Now the upper tribunal again only modified, and this time without compensation, and said that the PD rights arguably indicate that the proposed use is reasonable, but again drew a distinction between PD and Planning Commission. So as I say, it's perhaps a little bit surprising that we have this distinction being drawn in the case law. It doesn't seem to make a huge amount of difference, it would appear, but it does seem a bit surprising given that the whole point of PD is that it's a deemed grant of planning permission, so the development has been considered reasonable, albeit on a very broad level rather than on a case-by-case basis on application. So discretion then, the last port of call. So if we assume that you have cleared those jurisdictional hurdles, you are now at the discretion stage, and the leading case here remains the Alexander Devine Children's Cancer Trust case from the Supreme Court. So here you may remember you have a situation where you have a developer who was granted planning permission for 13 affordable homes on land that was burdened by a covenant. And the covenant prohibited the use of the land for anything else other than a car park. It was found that the units, or some of the affordable units that were to be built, would overlook some of the children's private gardens at the hospice, and some would also share a boundary with them. And so there were two important factors here. The Supreme Court considered that there were two particularly important factors here, and it's the judgment of Lord Burrows that's particularly important. Firstly, there was unencumbered land on which the units could have been built and for which planning permission could have been obtained. And secondly, this is a ground AA modification or discharge, and it was relying on the public interest test. The developer had only been able to meet the public interest test because it had proceeded to build in breach of covenant. So once the affordable units had been built, of course it would be contrary to the public interest to enforce a covenant and tear them down. Had the developer sought modification or discharge before building the affordable units, then they would not have met the public interest test. And the court was very strongly of the view that a wrongdoer should not be able to rely on the state of affairs that they've brought about by their own breach to secure modification or discharge. Importantly as well, the Supreme Court confirmed that the conduct of the applicant, so in this case the developer, was not relevant to the jurisdictional stage. So in this case, jurisdiction could be cleared, but it is relevant to the discretion stage. And this is where the application fell down, and it was the developer's conduct that caused the application to fail. So the really important lesson that we learn from Alexander Devine is that cynical breaches are to be deterred. And just because you clear the jurisdictional hurdle in no way means that you are going to secure modification or discharge. And at the discretion stage, the conduct of the applicant is going to be particularly important and will be looked at quite closely. So that's my whistle-stop tour through section 84. My email address is on the slide there if you have any questions. As I say, hopefully we'll have some time for Q&A at the end. I was very proud of generating my QR code, so please feel free to scan it and link in. And I believe as well the slides will be shared in due course. So that's the warm-up act completed. I'm going to stop sharing my screen and I'm going to hand over to the main event.
Thank you very much, Natalie. No, that was super, really, really interesting. Thank you very much, everyone. I'm going to be giving you a whistle-stop tour on how fraudulent misrepresentation can arise in residential conveyancing. Um, Today's topics, I'm going to look at seller-vendor duties of disclosure that arise in the sale of land. And then I'm going to give you a quick recap on the elements of the cause of action fraudulent misrepresentation. To illustrate sort of how it arises and the approach of the courts, I've chosen two slightly older property dispute cases. There's plenty of cases out there. Japanese knotweed is one. Rights of way, of course, but property disputes is something I've had a bit of experience in myself as a practitioner. I'm then going to look at a more recent decision this year in the High Court. That's Patarkatsishvili and Woodward-Fisher, which some of you may be aware of, which gives a good overview as to, again, how this is all approached by the courts, including on the remedy side of things. And then I'm going to end with some key takeaways should you find yourself advising those in the process of sale or concerned purchasers. So, on vendor duties of disclosure, our starting point is that caveat emptor applies. That's a very old principle. It simply means buyer beware. You can see traces of it back in old cases such as Fox and McCreth from the 1700s, where the Lord Chancellor explained there was no duty of disclosure between parties in a land transaction. It's also been enshrined in the standard conditions of sale at clause 3.2.1 that a buyer will accept property in the physical state it is in at the date of the contract. So what effectively this means is that there's no general duty of disclosure that is placed upon sellers when they are selling property. But there are a couple of exceptions, so to speak. So the first is in statute. There's the energy regulations from 2012. Those require disclosure of certain energy performance information. There's also voluntary industry code. So the Consumer Code for home builders imposes certain duties of disclosure on property developer builders when they're selling new builds. But obviously that's quite limited. And sort of to temper all of this, a practice has arisen of pre-contractual inquiries, and they've simply become the norm as a matter of practice. And what's been developed is the Law Society's protocol and their property information forms, also known as a form TA6. These are totally voluntary. They don't actually have to be answered by a vendor. A vendor can simply choose to leave certain answers blank if they wished. But I'd say good luck getting a sale across the line if you don't have a good reason for why you can't answer something. And it's typically these Law Society property information forms which contain a whole host of questions for a vendor to answer, such as whether there's been any disputes about the property or neighboring property, which we'll look at now next. Japanese knotweed, whether there's been any invasive species, vermin, as we'll see later on in the Woodward-Fisher case, and other information about rights of way. Flooding is another one. And it's the answers to these which can give rise to misrep claims. So in terms of fraudulent misrep, there's four ingredients, namely that the defendant makes a false representation to the claimant, the defendant knows the representation is false or alternatively is reckless as to whether it's true or false. The defendant intends the claimant should act in reliance on it, and the claimant does act in reliance on the representation and in consequence suffers a loss. So what I'd say is that really ingredient one describes what the defendant does. Ingredients two and three describe the defendant's state of mind. And ingredient four will describe sort of what the claimant has done in response to the defendant. And it's important to note that if the defendant believes the representation they are making is true, then it cannot be liable for fraudulent misrepresentation. In terms of the standard of proof, it's the usual civil standard of proof, balance of probabilities. But what the courts say, and I've put up the UK insurance and gentry case, is that claims for fraudulent misrepresentation need only be proved to the civil standard, namely balance of probabilities, but because of the improbability of persons acting fraudulently, more convincing evidence will often be required to establish fraud than other types of allegations. So what the courts are saying is it's the same standard of proof. We're not going to a criminal standard, but the quality of the evidence that you advance needs to be that much more convincing and cogent for a judge to sort of say, yes, I believe, I conclude that a fraud has been perpetrated here. And then in terms of remedies, there's a few different ones open. The most powerful of which, of course, is rescission, but whereby the contract is effectively unwound by the court. You will typically see that in much, particularly where it's a totally disastrous contract and terrible fraud. In some of the cases I've seen, people don't want to unwind the contract so much as they wish to recover uh, the difference in value between the property as represented and purchased versus what it would have been worth had the representation not been made. So, for example, had they known about the Japanese knotweed or the flooding or the neighbors from hell, actually they would have negotiated a 20% price decrease, and that's what they want. But even if you claim rescission, you can also claim damages alongside. Their damages for fraudulent misrep are designed to compensate the representee for all loss which can be properly said to have been caused by their reliance on the fraudulent misrep, subject always to a duty to mitigate loss after you've discovered the fraud. And why you might want to do that alongside rescission, as we'll see in the Woodward-Fisher case, is there will be costs of purchasing a property, such as stamp duty, moving costs, legal fees, etc., which even if you unwound the sale contract, to put you back in the position you would have been but for the representation, you will need to be reimbursed those expenses. Of course, rescission is an equitable remedy, and so there are bars to it which may prevent it from arising. There's typically four. The first is that the parties cannot be put back into their pre-contractual position. So that's typically called impossibility of restitutio in integrum. The second is a bona fide third party without notice has acquired rights under the contract for value, and their rights would be prejudiced were rescission granted. So effectively an equities darling type of situation. Affirmation by the victim will bar rescission. And then the last one is undue delay. So in effect, the latches bar to equitable relief may also operate. So turning to our first dispute, the first one I've chosen is a case from 2002, reported 2003, called McMeekin and Long in the High Court, a decision of Justice Astle. Here, the claimant had purchased a residential property which at its rear had driveways, and it also had a private access road. The property information form contained two questions of note for this case, which was, did the seller know of any disputes about this or a neighbouring property, and whether they had received any complaints about anything they have or have not done as owners? And they answered no to both. Well, it turns out the McMeekins moved in, and there had been a number of disputes or complaints relating to the use of the private access road by certain neighbours, including one parking a dilapidated caravan which blocked access to driveways, and another complaint about the dumping of bags of rubbish. What the claimants allege is that the defendants deliberately, or at the very least carelessly, did not reveal that they'd been involved in disputes about the access road, and that similarly there'd been neighbouring properties who had been in dispute with them. What Justice Askell found is that the evidence supported that there had been a dispute about both the parking and the rubbish, and that they fell within the ambit of the question in the property information form, as the disputes were to be disclosed about the property sold, but also any neighbouring property. Further, that the complaints received about anything the seller had or had not done as owner were required to be disclosed. What the court found is that there had been an atmosphere of confrontation between neighbours and the other occupants of the houses of the road, and that this was a continuation of a running dispute, which was a continuation of the problem that was suffered by the occupants when the defendants were there. And that was precisely the kind of information which must be disclosed to a potential purchaser for them to be able to make up their minds whether they wish to buy a property, with the running of constant disputes and antagonism existing between the owners of the access road and those who have rights of way over it. And what the evidence had found is that the defendants knew or ought to have known that there were these disputes. And I think what's helpful in this case is the emphasis placed on the language in the form. It's that it's clear. But what Justice Astle said is that it's not a lawyer's form, but one which is designed for everyone to be able to understand. And I think this is an important point which crops up again and again in these types of disputes. The property information form is designed effectively for, everyone, Joe Blogs on the street, to be able to read it and understand what's being asked of them by a potential purchaser of their property. Therefore, it's not expressed in very technical language, save for obviously certain bits which are to do with like rights of way and easements. But certainly in something like the property disputes, time and time again, what the courts are emphasizing is they'll take a contextual but everyday approach. They're not going to take a limited view as to what a property dispute or a complaint is. And in this case, the High Court found that yes, there were complaints. Those were disputes. They were about the property and what they had or had not done. And when you answer no, despite all of that going on, that is a misrepresentation, and the knowledge was there on the buyer, on the sellers, to turn that into a fraudulent misrepresentation. Turning to the second example of a property dispute, this is from a couple of years later. It's a case of Doe and Skegg, another decision of the High Court, a decision of Justice Pelling. Again, it's a case where someone had answered no to, do you know of any disputes about this or a neighbouring property? What had happened was that the sellers had experienced problems with their neighbour's son, who they alleged had trespassed on their drive and harassed them. They'd actually gone so far as to have written a letter to their neighbour threatening legal action unless their son had desisted from the behaviour. And they decided to simply sell the property, and the claimant purchased it. And of course, despite the accusations of trespass and harassment and the letter having been sent, they'd said no. And of course, the claimant moved in, discovered that the neighbour's son was continuing his trespass, and decided to bring a claim for fraudulent misrepresentation. What Justice Pelling said is that it was not necessary or desirable to attempt a comprehensive definition of what is meant by dispute in the context of property information form. So again, to seeing the courts taking a fairly pragmatic and expansive view. And he said that in interpreting whether there was a dispute about the property, a dispute concerning trespass fell within that. And I think that's pausing there. It's quite an important thing to note. It's a form of property tort. It obviously involves the actions of an individual. It's not the same as, there's a crumbling house or something like that. Or there's an issue over rights of way. The very actions of a third party trespassing onto the seller's land, is capable of constituting a property dispute. And what the judge said is that the word about in the context means no more or less than concerning the property, and there could be no doubt that trespass came within that meaning. And he goes on to say that the question is capable of covering a number of different disputes, from boundary disputes, building disputes, disputes concerning disputed rights of way, disputes concerning other easements and the like. I do not think it can be limited to that. So I think that's something to bear in mind when you're advising on either a seller, purchaser, or indeed someone who's aggrieved following the purchase of land, that the courts will take a wide and contextual view of what a dispute concerning property or neighbouring property is. What I think is interesting is that this case was brought as a fraudulent misrepresentation case. And what Justice Pelling noted, he said he questioned why the claimant would wish to persist in an allegation for fraudulent misrepresentation, given the cause of action under Section 2.1 of the Misrepresentation Act 67 had been met, which of course is an easier cause of action to establish, because you don't need to go further and prove the fraud and the mental state of the defendant. It's just simply, it's sufficient that had it been made fraudulently, you will get through on that cause of action. And he thought that it may be because the claimants thought it more likely that they could succeed a claim to exemplary damages. But of course, he noted in the course of the hearing that the test for exemplary damages is wholly different from the test of fraud. And that, in short, there's a reversal of the burden of proof in the 67 Act claim, because a defendant must prove reasonable belief in a claim for fraud, but in the misrepresentation case, but in a fraud and misrep case, but in a Misrepresentation Act case, it's for the defendant to prove their reasonable belief. So obviously there's benefits to bringing a fraud claim, which we'll come on to in the Woodward-Fisher case next. But certainly it's a clear sort of, I think, warning sign from the courts to claimants that, just simply going after on a fraud basis may be making a more difficult case for you. And indeed, as a point of practice, when you deal with certainly these type of claims, sometimes you, or indeed a defendant, may have the benefit of a legal expenses insurance policy through their home insurer, which will cover these types of disputes. But there can be, in some of these policies, an exception for fraud cases whereby an insurer will decline to cover where fraud claim is being brought against a defendant. So you may wish to consider whether you definitely need to go sort of that, as far as pleading fraud, because it may make it harder to settle a case if the defendant is not insurer backed. But what happens when you really need to do it? Well, that's this case, Patarkatsishvili and Woodward-Fisher, which I like to call the Moth Mansion case. And you'll see my AI-generated clip art there of Mr. Moth enjoying his tasty meal at the expense of the Patarkatsishvilis. This case concerned Horbury Villa, Ladbroke Road in London. It was purchased by the defendant in 2012 and renovated to, I think, over 200% of its original size. I think it was purchased for about 10 million, and then there was a further 10 million spent renovating it, which included a double basement, among other fancy mansion-like extensions. It was sold to the claimants for 32.5 million. What Justice Fancourt noted was that it was an unusually large and attractive property, which I think is something most of us would like to see on Rightmove for any property that we're thinking of selling. When the defendant and his wife were in situ as owners, close moths started to appear in early 2018. They instructed Rentokil and Environ pest control experts to look into it and provide opinions on what might be the cause and how to treat it. There was conflicting opinions. So Rentokil immediately said it's the natural wool fiber insulation that had been installed during the renovations, which is the source. Environ was a little bit more, I think, optimistic, but ultimately they concluded in June 2018 that the cause of the infestation was, in fact, the insulation that had been installed. And despite multiple treatments, the problem did not go away. In parallel to this problem appearing and the treatments being undertaken, the property was marketed discreetly for sale. And the claimants came along and they viewed the house 6 or 7 times between spring of 2018 and November 2018, and then finally agreed a sale in February 2019. Now, the claimants, very wealthy family, they had a limited company that was sort of their family office and finance house that acted as their kind of go-between agent between them and their own solicitors, Farrers. The property information, well, they purchased the property, moved in. Obviously, immediately became apparent that the mansion was riddled with moths. They were eating their clothes, very expensive clothes, as you can imagine, for people who have 32.5 million to spend on a property. And they spent over £300,000 removing the insulation and obtaining moth treatments, but it still wasn't successful because the infestation had really embedded into the structure of the property. And interestingly, they were able to obtain the reports from Rentokil and Environ because having gone to the main local pest control companies, those pest control companies said, well, actually, we visited this property before, and this is what we had concluded, and this is what we had told the defendant and his wife. And lo and behold, they decided, well, this was a misrepresentation. It's fraudulent, and we're going to bring a claim for rescission, return of the purchase price, and damages for associated costs. And just pausing there, something that's is really apparent in these cases, and indeed in cases I've acted on in practice, is that it's surprising how often in these cases there will be a document or there will be emails which a victim purchaser will be able to obtain because they move in, they discover a problem, and then they talk to neighbors. And so they might find that there was an email chain of all the neighbors about the trespass that's being committed on a daily basis. Or, there's flooding in their garden and they get onto the local council and lo and behold, the local council has records of flooding complaints from the previous owner. And it surprises me as to how often this happens that, people don't think that their neighbors will talk to whoever they sell their property to. And I think when you're advising a claimant, it's always important for them, I think, to try and do a bit of legwork, talk to neighbors, see if there's any text messages or emails that someone might be willing to forward to you. Because if you can get something like that, such as a report that the defendant may have had, or an email or a text message, it's going to make your claim that much stronger and easier to prove. But in terms of the property information questions, they're different ones to what we've seen. These ones were about whether the property had been affected by woodworm, dry rot, timber infestation, decay, but importantly for this case, vermin infestation. So no reference to insects or moths. It obviously goes on to ask, supply a copy of any report, and is the seller aware of any defects in the property which are not apparent on inspection? And then it gives examples why it might not be apparent. And the seller's answer was that they were not aware of any such matters affecting the property since the renovation and extension works. They went on to say that saves have been disclosed and documentation provided. There were no defects, or sorry, no reports. And then, of course, that they were not aware of any defects, but has not had the property surveyed, so no warranty can be given. And the claimants, having received this, the claimant's conveyancing solicitors produced a report concluding there was no reason not to proceed with the acquisition. They then informed the claimant's agent company that there were no red flags, which in turn told the claimants there was no red flags and they could proceed with the purchase. And of course, upon moving in, the damage and the issue became apparent. And just to give you a flavour of the value of the claim, of course, it's the return of the 32 million and a half purchase price, but damages included 3.7 million pounds in stamp duty fees, 383,000 pounds being the costs of remedial works, almost 2.5 grand for closed damage, and 891,000 pounds for loss and enjoyment. So what did Justice Fancourt decide? Well, the defendant's answers were misrepresentations. On question 2.1, which involved, well, were the moths vermin? What Justice Fancourt said is that this is to be determined by context of the representation and the question. And he found that vermin is capable of meaning animals or insects which are capable of infesting a house and causing a problem, such as damaging the property, adversely affecting enjoyment, or giving rise to an expense to eradicate. And that when one looked at the documents created by the pest control companies, this was clearly an infestation, and that the moths were vermin for the purposes of this question. So we can see again there's a willingness by the courts, I think, to take an expansive everyday approach, not simply saying, well, vermin can only mean one genus of animal, it's rats or it's mice. It can mean more than that. And I think that that is to be welcomed because, again, there shouldn't be too technical a approach to these questions. The report in relation to 2.2 meant nothing more in the context of this question than a document that reports on vermin infestation or on the fabric of the house. And that's what each of the reports did in this case. And there was no basis to limit report to a formal document, which is what the defendant tried to argue, such as a fully reasoned written opinion. They were simply documents concerning the fabric of the property. And there was no basis of saying that insulation, because it existed within the plasterboard, did not form part of the fabric of the property. It was not something that could be easily removed. On question 2.3, again, there was no, it was rejected by the court, an argument that defects in the property was limited to structural defects. What the court noted is that is not implicit in the word defect or in the word property. And what the defendant tried to argue was also that that example in the parenthesis given about, you can't access it for inspection due to property. And well, that didn't simply mean then you were only concerned about things which were hidden by chattels, because the court noted, well, then you'd be drawing a distinction between, a defect hidden by a wardrobe that can be moved, which would be, a disclosable defect, versus those which might be hidden behind plasterboard and will require a sort of a destructive inspection to get at. And really, again, what we're seeing is taking a broad approach. Effectively, if a seller chooses to answer these questions, they need to answer them fully and honestly. And so then we get on to the next element, which is, well, look, did the claimants know of and rely on the replies? What the defendant argued is that the interposition of the solicitors and the third-party company agent meant that the claimants were not personally told of the responses to the replies and therefore could not have known of them and could not have relied on them. What Justice Fancourt stated is that as a matter of law, a solicitor's knowledge of the content of replies to pre-contract inquiries is to be treated as the client's knowledge. And I found it would be that there would be no difference if the solicitors reported to an interposed agent company who then confirmed to the claimants that there's no red flag. So that's the court, again, taking a very pragmatic approach to this. It's simply, when you have an agent, knowledge of your agent is typically going to be imputed to the principal, and that this is an example of that in practice. You'll see I've got quotes there from paragraphs 86 and 100 of the judgment, which explains that. And I think it's quite important to see that inducement will be presumed once knowledge is established, if representation is made with the intention that it be acted upon. And I think it's very difficult for defendants to argue in these sorts of cases that, well, I gave I volunteered an answer to the property information form, but I didn't intend for it to be acted upon. Well, you obviously, it seems that you probably did, because if you didn't intend for something to be relied on, you likely wouldn't give it when you had no obligation to do so. And typically the reason people are giving these answers is because they want their property to sell. So we'll see that there is a presumption in a claimant's favor regarding reliance. And then we'll see again that this presumption is repeated at paragraph 100. It's obviously a rebuttable presumption, given Justice Fancourt makes the references to rebutting by evidence. But I think that's very helpful. It'll certainly help claimants get over something which I think defendants almost always try and argue, well, you didn't rely on this, you got your own report, etc. Well, no, if their solicitors know about it, and if they've acted on it and purchased the property, you're going to have a presumption in the claimant's favor. Burden will be on the defendant then to discharge that, and that will typically be through cross-examination. On intent to defraud, that was also established. The case of Derry and Peak, a decision of Lord Herschel, states at 374, fraud is proved when it can be shown that a false representation was made, one, knowingly, two, without belief in its truth, or three, recklessly or carelessly, whether it be true or false. Justice Fancourt very helpfully confirmed that while motive is irrelevant to liability, its absence or presence may be highly relevant on the question of whether a defendant knowingly made a false statement. So it's part of the wider, subjective factual matrix as to the defendant's state of mind, which its absence or presence, will allow an argument to be made as to, well, why would you have made this representation, this false representation? And depending on that motive, it may be easier to test if it was done so knowingly. And what Justice Vancourt said is that in relation to the second of the questions, the defendant knew that his response was false because he was aware of these reports and had in fact read them or had them read to him by his wife. And he also knew that there was a hidden defect in the property in the form of the infestation. So that fell into the first category of a knowingly false response. In relation to the first one about the infestation of vermin, that was held to be an intent to defraud on the reckless as the true or false category. And that's because he did recognize the defendant that the moths were vermin or potentially vermin. But he obviously didn't go on as far as to tell his solicitors what had been reported. But he did mention the moths to his solicitors, and that indicated that he did not confidently believe the moths were irrelevant or that there was no infestation. And so in that context, the failure to provide the information on the report indicated a wish by Mr. Woodward-Fisher to conceal. And that, in effect, he was grossly negligent in the reply by failing to give the true picture and to check expressly with his solicitor whether a moth infestation was a vermin infestation in this context, or he was dishonest in concealing the true picture on the basis that he knew or suspected he might have had to disclose it when answering the question. So fraudulent misrep have been made out. So the question then turns to the remedy available to the claimant. So this is where the case, I think, is also quite helpful in general in the law of fraudulent misrepresentation. The primary remedy was rescission. What the defendant argued is that is that there was a discretion, notwithstanding the finding of fraud, that the court could simply refuse rescission. That was rejected. You can see there some of the quotes, but what was said at 187 is that once you establish the fraud, any residual discretion falls away. That can only, simply that a defendant can argue, well, it's just simply fairer to give a claimant damages. No, if a claimant's seeking rescission and they've established fraud, they're entitled to rescission subject to the equitable defenses. In this case, 3 equitable defenses were advanced. First, delay, affirmation, and impossibility. On delay, what's confirmed is that it'll only bar if it's culpably excessive or gives rise to a benefit that cannot be restored or causes prejudice to a representor, rendering rescission inequitable. I think on that last one, where you have the representor being found guilty of fraud here, I think it's going to be quite a high bar for them to show that they've suffered a prejudice. Here in this case, there was only a 6-month delay between knowledge of, or 7-month delay between knowledge being established and ultimately bringing the claim for rescission, and that was not excessive. It was argued that, well, they'd affirmed the contract by remaining in the property. That was rejected because affirmation requires 2 things. First, an unequivocal act or statement, and staying in the house was equivocal. And secondly, communication of that act or statement to the representor, of which there wasn't. And finally, on impossibility, I think it's quite interesting. What the defendant argued was, well, I actually can't afford to make restitution, and also the claimants have been in the property for 5 years or so, and they'll have to give something back. to me to account for their use of the property. And what Justice Fancourt said is that, well, impossibility is about the counter restitution point. It's not necessarily about the defendant's ability to make restitution. And in light of the defendant's pleaded evidence that he couldn't afford to repay, having, I think, lost some money on bad investments, what the judge ordered was that, in fact, there'll be restitution in the form of a rectification of the title register, vesting the property back in the defendant. But that would also be coupled with an equitable charge in the claimant's favor, such that they would effectively get repaid the purchase price, or as close to, once the defendant sold the property in his name again. And that the court would also then give monetary allowances in the defendant's favor of the use value of the property to the claimants, which was valued at about £1 million a year, notwithstanding the MOTS, mind you. And I think that's two important things we can take away from that are, first, that the court will take a practical approach. They will be willing to grant a practical, flexible remedy in order to achieve restitution in the rescission type of case. And then secondly, that if you are in one of these cases and you're acting for a defendant, and you're trying to say, well, actually, I want some counter restitution, make sure you've got good expert evidence as to the market value of the property, but also the rental value of the property on a weekly basis. The judgment only came down about 5.5 years after the property had been purchased, or 4.5 years thereabouts. And as a result, that gave rise to a roughly £4.5 million counter restitution that would have to be made, which would be set off against the various damages that were awarded. And I think just for completeness, because I don't have time, I'll simply say that the claimants were successful in getting damages for their consequential losses, including stamp duty, land tax, legal costs, and repair costs. So, what are our key takeaways? Well, I think, look, a seller has no obligation to answer inquiries, but if they decide to do so, honesty is paramount. The courts, yes, they reaffirm caveat emptor. It remains part of English law, but a seller cannot conceal known problems by giving incomplete or false responses. There's no broad duty to disclose, but withholding information that makes an earlier statement misleading is equivalent to misrepresentation. So takeaway, honest disclosure is paramount. If a seller answers at all, they must do so honestly and not omit key facts. The courts will take a contextual, everyday approach to construction. Justice Fancourt's decision is consistent with those earlier cases of McMeekin and Long and Doe and Skegg, that the meaning of questions in a property information form should be considered in context and given an everyday meaning. I think a guiding star is that if a seller is worried about something, about whether they should disclose it when answering, then it's probably, if they don't include that, they may be found to be reckless as to the truth of their reply to the question. We now have confirmation that reliance on knowledge via agents isn't going to be an issue. This is a common sense approach. It's also very helpful to know that reliance, once knowledge of the response and the entry into the contract is shown, will be presumed, which gives, I think, defendants less room to maneuver when defending a case. It's important when you're seeking rescission to be aware of delay in affirmation. Be careful of unreasonable delay if you're advising victims. A few months, obviously, in the Moth Mansion case was acceptable, but it's always going to depend on the facts. It'll also give rise to a risk of significant counter restitution, depending on how long a claimant has been in occupation of the property. Obviously, claimants had problems due to what's not been disclosed, and they've had to leave the property, such as where they've got, dangerous, aggressive trespassers on the land who they should have been warned about. They're less likely to have to make a monetary counter restitution because they will have been deprived from the use of the property. I think as well, in terms of affirmation, the emphasis on communication by the court is very useful. But of course, you have to be careful because conduct may be sufficient to give rise to affirmation if a defendant is aware of it. And finally, the 2 points I'd make is rescission's a flexible remedy. Just because it might seem you have an impecunious defendant doesn't mean that there won't be a way for the court to unwind the transaction. And finally, I'll say consider negligent misrepresentation, especially in damages only claims. You're going to have a much easier task of establishing liability. But of course, there's there's also defences available and to a defendant under the Misrepresentation Act of an honest and reasonable belief. And so you need to be aware of those. But yes, that is our whistle-stop overview of fraudulent misrepresentation and property conveyancing. There's my email address if you have any questions. And of course, very helpfully, our marketing team has generated a QR code for myself if you'd like to connect on LinkedIn. I'll hand over back to Natalie.
Awesome stuff. Thank you very much. We're a little bit over time and there are no questions in the Q&A. So if anything does occur to you and you want to get in touch, please do. You've got our QR codes, you've got our email addresses. The last thing to say is that the next junior programme, we have a little bit of a break for the summer, so the next junior programme is on the 18th of September. It's a bit of a treat because it's in person. The topic is restructuring and insolvency, and it will be presented by Chloe and peers. So no doubt the marketing team will send around invites in due course, but if you are available to, do please join us on the 18th of September. And I think probably that's it from us for today. Like I say, do get in touch if anything occurs to you. I believe the slides will also be circulated in due course. But otherwise, thank you very much for joining us and nice weekend when we get there.
Thank you. Goodbye all.
Bye.